Hello, good afternoon, and welcome to The Law. This is your legal light. It is your help law. This week, the trial of a number of people accused, suspected, and put on trial for high treason has come to an end. 6 of them were convicted to hanging until they die, and 3 of them escaped. They were found not guilty. We've heard about treason, high treason. What exactly is that offense? So, I have 2 gentlemen, colleague lawyers, who were part of the trial just ended. And so, their knowledge and experience on this area of the law is very fresh. They are going to help us to understand what treason is, what high treason is. I'm Samson Lardy Anyenini. We'll be right back. Welcome back. This is The Law. It's your legal light. It is your help law. And my guest joining me this afternoon to understand what constitutes the crime of treason in Ghana are Victor Kojoga Adaudu. He is managing partner, Lord and Lords Practice Limited. It's a law firm. Lamtig Apanga. He is managing partner, Prestige Partners. It's not new to this platform. Gentlemen, thank you very much for making time to join us.
Thank you. Thank you. It's a pleasure.
Right. So, as you know, here on our legal clinic, we make sure that by the time we are done, if you forgot anything at all, you will not forget the Law 101. So, here is the Law 101. And today it's a bit lengthy, but it is important. Article 19, Clause 17 of the Constitution 1992. It said, subject to Clause 18 of this article, treason shall consist only, A, in levying war against Ghana or assisting any state or person or inciting or conspiring with any person to levy war against Ghana, or B, in attempting by force of arms or other violent means to overthrow the organs of government established by or under this Constitution, or C, in taking part or being concerned in or inciting or conspiring with any person to make or take part or be concerned in any such attempts. What then is high treason? Article 3, Clause 3 says any person who, A, by himself or in concert with others, by any violent means, by any violent or other unlawful means, suspends or overthrows or abrogates this Constitution, or any part of it, or attempts to do any such act, or B, aids and abets in any manner any person referred to in paragraph A of this clause, commits the offense of high treason, and shall, upon conviction, be sentenced to suffer death. Thank you. That's by way of our Law 101. And because these are the articles or the provisions of law that we are going to dwell on extensively this afternoon. As we discuss, we'll continue to project it so that you get a lot more familiar if you have not been aware of these. So, let's begin with my senior colleague. When we say treason, what is it?
Now, Samson, good afternoon to our cherished viewers. I think that when we say treason, our laws does not, apart from describing what the treason is and what we should look out for as a treason, hasn't really defined in the interpretation or anything, has defined what is a treason. So I would want to go to maybe the Black's Law Dictionary, okay, where the dictionary talks about attempting to overthrow the government or of a country which you owe an allegiance. So anything you do to a country where you owe an allegiance to, then it becomes, or in aiding or helping the enemy to overthrow the country, the government. So these are the things that really is treason. Like, if I may read the Black's Law Dictionary, what it says.
Yes.
It says the offense of attempting to overthrow the government of the state to which one owes allegiance, either by making war against the state or by materially supporting its enemy. So this is the definition.
Either by making war.
Either by making war
or materially supporting the country's enemy.
The country's enemy. So these are the two distinguishing characteristics that defines what is treason. Now, when you come to our laws, apart from the description
in Article 1917,
which
is repeated in Section 180.
Section 180.
Yes, of the criminal offences.
Of the criminal offences. Now, if you see, there are two different, you could see, but if you read all, it is talking about the same thing. If you look at 180, 180 is talking about high treason. And Article 3.3 also talks about high treason. And the two of them, when you read it together, it talks about the punishment you suffer, death. Now, Article 1917 gives us the characteristics or the elements we have to look out for. Now,
so let's put that up again. It says levying war against Ghana or assisting any state or person, as you read from your Black's Law Dictionary.
Yes.
So you are either levying war against Ghana or you are assisting any state or person, or you are inciting or conspiring with any person to levy war against Ghana. So the qualifying activity is war.
Yeah, it's war. It's war. That is treason.
Right.
That is treason. Now, once all this description has been given, now within the Constitution itself, it also talks about conspiring, which is conspiracy. Now, conspiracy, all we say about conspiracy is when you are helping or preparation to the commission of a crime. That is a crime that hinges on a substantive crime. So the conspiring, you will find that in the Criminal and Other Offences Act, which is Act 29. So this has to be read together with, Section 24 of the Act 29. Then you can get the actual understanding of what is conspiring.
So let's stay there. Let's not be talking about the predicate offenses, the substantive offense. We are still on treason. We are not moving to high treason yet.
Yeah.
So what will you say? Because in Article 1917, which is repeated in Section 180, it has three different levels. First, you are levying war, or you are assisting another state or person to levy war, or you are inciting or conspiring with another person to levy war against Ghana. Then 2, you are attempting by force of arms or other violent means to overthrow the organs of government established by or under the Constitution. And then 3, you are taking part or you are being concerned in or inciting or conspiring, like he just said a while ago, conspiring with any other person to make or take part or to be concerned in any of such attempts.
Yes.
That's a lot.
It is broad enough to ensure that anyone who participates some way, somehow, in the process of inciting or levying war or conspiring with others, which means that even if you agree to act together with other persons, you would have fallen foul of the law. You would have been in breach and coming close to being accused of treason. Or where you even incite, you do not necessarily participate, but you incite other persons to overthrow or to levy war against Ghana. So you may even be outside Ghana, outside the jurisdiction of Ghana, and incite other persons to take arms or to go through some violent means to overthrow the existing government, and not necessarily the government, but even other organs of the state.
That's right.
So even where you attempt to overpower perhaps the military or the police or some other arms of the government, that or even parliament, which is a very significant arm of government, that seeks to overthrow the government, you would have fallen foul of treason.
Because he says overthrow the organs of government established under the Constitution. Absolutely. And where he talks about you don't have to have, you don't necessarily have to have done the act itself. Yes. It's good you are also here. I remember Koku Ayidoho. You were his lawyer. He went to the police station trying to help to get him bail when he was charged with this offense. What else can you say? How else can you present this? The part where you are not actually doing the activity, but you are involved in what he calls inciting or concerned with, that you may get into trouble. How else can you do it?
You see, when you go to Section 180, from 180, when you come to 181, 182, it makes difference into what is treason and misprision of treason, and treason felony. So, by the example you are giving, that's why you see in the US, they have differentiated constructive treason. Not ours is so broad. It is so broad that any little thing you do, inciting or conspiring, you could be brought under this.
You said they have differentiated constructive treason.
Yeah, constructive treason.
From what? What sort of treason?
From the treason, actual. Before you actual treason.
Okay,
before
so
you
there's actual and there's constructive.
There's constructive.
So help us with the differences.
Yes. Now, you see, in the US, treason against the United States consists only in levying war against them or altering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to be to the same overt act. Now, what?
Overt act.
Overt act.
Not covert.
Not covert. So for them, a speech, like we are coming to, when you make speech, and it says constructive treason is a speech that manifests a desire or intent to make war against the state or materially support an enemy, even though the speech is unaccompanied by acts that further the desire and intent. There is no crime of constructive criticism in US because treason requires affirmative act.
Okay.
It requires an affirmative act. So in their law,
you mean the speech alone is not enough?
The speech alone is not enough in their law. But whilst in our law, the Constitution has made it so broad.
Whether you do it actually.
Whether you do it actually.
Or you use speech to incite.
You use speech to incite.
Or you help other people somehow.
You conspire. Or you have even agreed.
Yes.
Or you stayed with people whilst they were saying it. and you never said anything, if you are brought under the constitutional provisions, it makes it so broad. However, if you are put under the Criminal Code Act 29, that makes the difference. Now, there are two different. The reason why we have these differences is that under the Criminal Code 180, where it says if it is high treason, you suffer death, the rest is a first-degree felony. The misprision, it says you know about it, you never reported. Treason felony, that whilst the act was going on, you knew instead of going to report to a police or report to a president that this is what is going on, so that gives you life imprisonment.
That's misprision of treason.
Yes, misprision.
Where you know about it, but you didn't report.
Yes, you didn't.
And it gives category of persons you should report to. It says
Okay,
that you
yes.
should report to the president or a police officer, not below the rank of an inspector.
Inspector.
So if you fail to do this, you would have fallen foul of the law. But here it's misprision of treason.
Yes.
And the punishment for it is a first-degree felony, not death.
All right.
You may suffer some number of years in prison, but not necessarily dying.
Okay.
And also,
And this is one of the offenses where the state places a responsibility on you to report treason.
yes.
So that if you are in a position and you know or have heard of or seen persons planning or undertaking steps towards treason or discussing anything to overthrow the government or organs of the government, and you hear of it, you don't report to the president or a police officer not below the rank of an inspector, you would have fallen foul
If you are found out.
if you are found out.
You began an intervention by saying, even by being concerned.
Yes.
Explain that.
Yeah, but by being concerned here is that you may be sitting at a beer bar. You have no business in that discussion that's going on, but you have overheard. Okay, and then it didn't end there. Perhaps you followed up by getting to know more. Even that you've shown concern. By being concerned, you've shown concern.
Not that you have incited.
No.
Not that
You've
you
conspired.
have attempted and
No,
conspired.
Not that you've conspired. Not that you even agree that they should go on with the other plan they have, but you have actually expressed interest by getting to know more about it. You have become a person of concern. And the law expects you that within reasonable time, you ought to have reported. If you don't report, you may not be found foul for treason, but misprision of treason catch up with you.
Now,
But you may be found culpable for treason itself.
Exactly. For being
Because
a person of
here
concern.
it says
Yes.
in 19 clause 17c that in taking part or being concerned in
Yes.
or inciting or conspiring with any person to make or take part or be concerned in any such attempt. Just the attempt,
Just the attempt.
not the actual thing that's been done.
In fact, what is even very unique about the offense of treason is that in most cases, it is those who fail who would find themselves guilty of the offense. If you succeed, who then will place you before court?
Right.
Of all the coups that we've had in Ghana, all those coups that they've succeeded, who has been tried?
Right.
Understand? But it is when you fail. So this is one of the offenses as good as suicide. It's the only offense that if you don't fail in succeeding,
Right.
you are likely to face punishment.
Yeah, because if you succeed, you form a government.
Absolutely.
And you determine what happens.
Absolutely.
Okay.
But there's a clause in our constitution that allows citizens to restore the constitution.
Right.
And if they do so, you may be found, you can come under Article 3A. Yes.
All right.
so Samson, let me just add. So you would see that within our law, the 19.7, it is on the basis of the C, 17 clause C, that they have found some of the people to have attempted and has agreed. That's why they have found themselves, and the penalty that has been given to them.
Right.
So it is on this that they said they took part of it, and it was an attempt. That they took part of it, they agreed. As to what the elements to what was seen or the inference of their agreement is a different matter.
Right.
But once you have made an attempt or you have agreed with somebody, then it is on this basis. So the young soldiers who were convicted were all convicted based on attempt. the charge of attempting to
Conspiracy.
conspiracy.
Or
Conspiracy.
Or conspiracy.
The abetment, two people.
Two persons
They
were
all
charged.
did.
They were, yes.
ACP Agozo
And then
And Colonel Gameli.
Gameli.
Right.
But they were all exonerated.
Right.
Because the evidence did not support the charge.
Right. Colonel Gameli, it was found that it was his subordinate who had mentioned him. And he had also, he had been found to have exchanged WhatsApp with a nurse of the hospital belonging to MacPalm. Right. Okay.
But there was actually an allegation that he made confessions of knowledge
which they couldn't prove.
and they couldn't prove it under cross-examination.
That's right.
And so failure to prove that inures to his benefit.
Right.
Yes.
Great. All right. So if you are just joining us, you are on the law. This is your legal light. It is your health law. We just began with treason, and we have gone to some other aspects of it, but we are going to high treason. And the two gentlemen in the studio right here, Victor Kojoga Dawudu and Lamting Apanga, have just come out of one of such trial. And so we are seeking to benefit
As lawyers.
as lawyers, yes. We are seeking to benefit from their fresh, reading around and practice around this. Right. Now, shall we now move to what high treason is? We've just dealt with treason, which it says consists in levying war against Ghana. You levy a war, or you assist another state or a person to incite, or you conspire with another person to levy war. So you are levying war against Ghana. Or you are attempting by force of arms or other violent means to overthrow the organs of government. And then C, number 3, you are being concerned, you are taking part in, or you are being concerned in, or you are inciting, or you are conspiring with some other people to take part or be concerned in it. So let's begin with you on this one. What then is high treason? That would mean a treason that is higher.
So there are two sets. The Act 29, which is the Criminal Offences Act, establishes treason. And then the Constitution provides the basis for high treason. Article 3, subclause 3A says clearly that any person by himself or in consent with other persons through violence or other means attempts to overthrow, abrogate the Constitution shall be liable for high treason and will suffer death. The punishment, unfortunately, for both treason and high treason is the same. You suffer death. But in high treason, you can act alone, on your own, all by yourself. Or you may act in concert with other persons. You may also act through violent or non-violent means. It says any other means to overthrow the Constitution.
Unlawful means.
Unlawful means. Unlawful means. So your means may not necessarily be violent. It could even be by way of speech, which may not be violent, but by the conduct. You may also be planning something that may not be violent, but by the way you conduct yourself, and that conduct being unlawful, that seeks to overthrow the government or the Constitution, abrogate the Constitution, you fall foul of high treason. Simple as it is.
Victor, overthrow the Constitution. What does that mean?
Overthrow the Constitution is that the Constitution will no more be in operation. It says this, it comes to an end.
It says to suspend or overthrow or abrogate the Constitution or any part of it.
Yeah, so that means that all the arrangements we have made when it comes to the organs of government, Parliament ceases not to be there again, the executive, the appointees, everybody, it comes to a halt. So that's what it says. But let me also look at the high treason. You know, the high treason if you look at it, the kind of punishment that comes with it and the mode is what normally, for me, changes the whole dynamics. If you look at the treason, yes, you go for death. And the other ones talks about first-degree felony. Those other ones. But now when it comes to high treason, the standard is so high. That is why you need 3 high court judges. 3 high court judges to sit. If it is only treason or treason felony, the law is that you have to go a judge with the jury. A judge with the jury. Now, so you would see this particular case, when they were charged with treason, they were charged with treason felony, they went through the committal proceedings, and we got to the High Court when a jury was empaneled. So, jury was empaneled, it was to start hearing the matter on Tuesday, only Thursday to go and report, and they were arrested. So that was when it was changed to high treason. That now we had to come before 3 high court judges. Now, if you read the high treason from the Blacks, you see
Black's
that
Law
Black's Law Dictionary from the medieval days is the kind of punishment they give you that makes it, they call it high treason. If you allow me, I'll read it from here, the Black's Law. The judgment of high treason was, until very lately, an exception to the merciful tenor of our judgments. The least offensive form which is given in the books is that the offender is carried back to the place from whence he came, and from thence to draw to a place of execution, and there hanged by the neck and cut down alive, and that his entrails be taken out and buried before his face, and his head cut off, and his body divided into 4 quarters, and his head and quarters disposed of at the king's pleasure. The king's pleasure. So that is why it was the king that at that time, to make it high treason, you have to be hanged. You have to be executed.
Is that why in this particular case of Dr. McPalm, the judgment concludes by saying this? Uses same words that you have just referred to here.
Yes.
It concludes by saying, this court, having found you guilty of conspiracy to commit crime, namely high treason, and high treason as your respective cases may be as contained in this judgment, the sentence of the court upon you is that you be taken from hence.
Yes.
You just read that from
Yeah, I just from Black.
You be taken from hence to the prison designated by the Republic.
Yes.
And that you be there hanged by the neck until you are dead, and that your body be afterwards buried in such a place as the president may order.
At his pleasure.
And may God have mercy on your souls.
Yes. So this is, for me, that's why the high treason. However, I think upon hindsight, and I believe that I'm using my words advisedly, the learned Attorney General led the court in the kind of imposition, especially when it comes to the sentence. Because, you know, our attention, we were made to believe by the media and that the death penalty and others have not been assented to. That's what we've been made to believe. Apparently, that death penalty has been assented to by the president.
Yeah, it has, but the president appears, there has been communication that suggests that even though it was assented to earlier, there's a communication official that suggests that it has not been assented.
No, it was assented, it's been gazetted on the 2nd of August, 2023. So if that was the law at the time, and it says that every death, if you suffer death, should be committed into life imprisonment, it means that that was on our statute book before judgment was given. And I'm sure the court wanted to find out. So once the thing had been assented and it's all over, it was until I saw gazetted. It was assented and not gazetted, we could but it was assented and gazetted. I realized that no, maybe we had been misled.
So if you are getting a little lost, there has been a process in Parliament for the repeal of the death sentence. But are there not different death sentence regimes? There is one in the Armed Forces Act.
Yes.
Is that not what has been repealed and not the one in the Constitution? Because the Constitution, this one in the Constitution, you need a process other than what was undertaken to repeal it. So the death sentence is still, if you are charged under the Constitution,
yes,
the death sentence is still on your head.
Yes, yes, but the execution. So that has not been defined. The mode has not been defined. But we have law. You know, the death sentence, it goes with about 9 offenses. That is, it goes with piracy, hijacking. It goes with the armed forces when there's mutiny, or when you are in command of the army and you would give the unit and others to the enemy. You are not able to discharge. Those are the things that...
Desertion.
Desertion and the rest. It comes with the death.
Okay.
Now, when we have a law, this is my argument. When we have a law which has now prescribed what is death penalty, all the rest have not described what... It just says you suffer death. Now, there's a Death Penalty Act, Act 1101, which has been assented to. It's become part of our law. It is my contention and belief that whilst going to give that sentence, you look at that law. Because at the time, the sentence, and don't forget Republic versus Boso.
But if you are charged under the Constitution,
exactly,
and the provision in the Constitution, which is still that you suffer death, and that has not been, amended.
What is curious is that the judges actually asked the Attorney General, has the President assented to that law? And the Attorney General told the court, in open court, that no, the President has not assented to it.
I think that's where the controversy is. I think there has been information in the public which suggests that
it has
the
not
President has not assented, even though we knew that he had assented earlier. So how do we deal with that situation?
So even if we are saying that the process for amending the Constitution, if this is supposed to amend the Constitution, it is wrong, there was no need to even inquire whether the President has assented to it in the first place, because we don't need an act of Parliament to amend this. We need to go to another process to amend this. And so that created some confusion and doubt in the minds of everyone. But what is more disturbing, that the Attorney General told the public that no.
To the court?
The court.
Okay.
That it has not been assented, when indeed we have found out that it has been assented and gazetted.
This was asked on the day of judgment?
Yes.
Not before that day?
No, on the day of judgment.
You would have had time to prepare to help?
Yes, absolutely. But Samson, this is the issue. The issue is that once we are going, and we will definitely go and test the law, that was a law that was on our statute book. If you look at the Criminal Code 180, where it also talks about high treason, it only says you suffer death, right? So if you read the two, it is the same rendition, the Constitution and that of the Criminal Act 29. So what is the intendment as to death penalty? If the sanction is death penalty, what is the intendment and the motive? Is it that our intendment, or with all the protocols we have signed, the international instruments, we have come to a point and we say that death should be converted into life imprisonment? I think that will be one of the issues that the Supreme Court will be able to pronounce on for everybody to come and understand.
Okay, since you are taking us already into the case that the court decided, the High Court decided on the Wednesday, the 24th of January 2024, let's go there a bit. And that is the case of the Republic versus Dr. Frederick McPalm, deceased. He died in the course of the case, and 9 others, right? So there were 10 in all. And 6 of the accused persons were convicted and sentenced to death by hanging, and 3 of them escaped. As I mentioned to you earlier, this is how the 3 persons escaped. According to the judgment, the 3 of them who escaped are the 5th accused person, the 7th accused person, and the 10th accused person. The 5th accused person is Colonel Samuel Kujo Gameli. He's a senior military officer. WhatsApp communication was discovered between him and a nurse of the Citadel Hospital. The Citadel Hospital belongs to MacPam, the doctor who is said to be at the center of all of this. Upon the arrest of MacPam and his friends, that's how he got arrested. Allegation that he confessed to knowing about the activities of the TAG group, they call it the Take Action Ghana group, in plotting a coup, was never backed with evidence. He was only mentioned by his subordinate to MacPam. He was said to be one to provide communication support for the group, for the coup. He was charged with abetment, and he got himself freed because the prosecution said he made a confession when they arrested him. The court said, show the evidence of the confession. The prosecution didn't have it. Now the 7th accused, Corporal Seidu Abubakar, he's with the Air Force Base. He was seen only once at the many meetings that the group had. He was seen in only one of those meetings. It was proving that he only accompanied a colleague of his, Ali Solomon, and he sat far away from a discussion that was ongoing at the next door beach resort. That's the only attempt, the only time he was seen in any such meeting. And he never participated in any of the meetings. He was never on any of the many videos of the group plotting activities. He was charged with conspiracy and high treason, and he escaped. Then 10, finally, ACP Dr. Benjamin Kwasi Agojo is a senior police officer. He was outside of the country when he was invited to join the group on a WhatsApp platform. And he was invited due to his public advocacy at the time. He donated 2,000 cedis to support medical outreach of the group, an NGO. He was told it was an NGO and was involved in medical outreaches. So there was no proof that he was ever on the group's executive WhatsApp platform where coup plot discussions took place. So this is how he got out. And the court said the allegations against him were not proven. The prosecution failed to prove mens rea, an intention, that he had an intention to assist or encourage MacPam to overthrow the government. He was charged with abetment, and he survived. In this case, does it become a bit, clear to you that because of the sort of activities that the people are said to have been involved in, potentially the crime of treason, there was reasonable suspicion, at least?
I think most of the people that had been sentenced and convicted and sentenced, is based on the conspiracy.
Yes.
The charge of conspiracy. Now, the conspiracy as to whether there was an agreement or not. For me, the interesting thing is that after reading the judgment and listening to the judgment, there are pieces of evidence that the defense has put that was not considered at all by the court. But if you say somebody, he must have knowledge, he must be there. Just like the 8th accused person. He actually went there with A7, who was acquitted. They were not sitting in the meeting. He was not even captured in any of the videos.
No, he said the A7, that is Seidu
yes.
Abubakar, he said the A8, the 8th accused person, is his friend, actually
yes.
his roommate.
Yes.
and that they went to buy fish.
Yes.
And then on their way back, somebody called his friend to come to the next door beach resort. So he simply followed him there.
Yes.
When he got there, his friend and that person were having their discussion, and he sat in a hut different from them. So that's how he got escaped.
Yes.
He escaped.
Yes, the two of them were not part of the meeting.
I see.
The two of them were not part of the meeting. It was the person who invited them, who is A9, that after the meeting, he went and beckoned him and they had a discussion. They had been friends. They had been families from Sandema.
Okay.
All along. So the 9 and 8 have been families since childhood. So for him, there was nothing to show that there was a role that he played. You know, so for me, it gives me some...
Was he not seen in some of the videos?
No, it was only one video. The other one is that he also accompanied A9 to Dr. Mark Palm's house.
So more than once?
Yes, and even in that, when they went there, he didn't even know. They were just going to meet. He said, let's go and meet my friend. So he was not even part of any meeting in the house. It was when they were going that A9 told him that we've been giving some money for transport. That has been all. Now, you see, you know, when it comes to criminal investigation,
people say you got one of your clients off or two of them off, then you have one or two who were convicted, and you are faulting the judgment. You are happy. You're happy about those who you got off, but those that you couldn't get off, you are not happy about.
That's not the issue. If for me, it is about the proof. It's about the defense. You know, as a lawyer, when it comes to criminal matters, even if the defense is so weak, you think it's so weak, you have to evaluate it. And I'm saying that the evaluation that has been done, if it was done just like it was done for 8-7, I'm sure most of them will have been off the hook. If you look at A2, you know, when they arrest you, and to say things that have been found belongs to you, you need to sign an inventory to show that in my presence, these things have been found. Where they said they have found the guns, the pipes, and the rest, A2 was not there. A2 was not there.
Interesting.
Are you getting it?
Yeah.
So this is why I'm saying that if some of the evidence, the defense we had put, I'm sure once the court looked at the evidence, because this is a man who says that he's been given a device to record all the processes. But there are processes that he says it happened, he never recorded. All he says is that I had forgotten my device. But these were instances that you have made allegations. There's an interesting one.
Okay.
You see where they said they found the sketch. The sketch, A3 says he drew it himself.
A2 is the blacksmith.
The blacksmith. Now, the soldier who came and said the sketch was found in Mark Palm's drawer. He said he drew it and he labeled all this. So at cross-examination, I just said, okay, if you drew it, then take a paper. The names you've written, how you labeled it, write the names for me. He wrote Appoint Parliament, Obechebi Circle. He couldn't spell it. He couldn't even write it. The handwriting is so different.
Okay, let's see what let me come to
you know,
Apanga.
Yes.
And there was this exhibit G13.
Yes.
And the exhibit G13 is a transcription of the meeting held on the 28th of July 2019.
Yes.
And it says, I read, in these discussions with A3 present, and which he contributed to, for instance, discussions were had with Dr. McPalm on how much ammunition would be needed and the casualties. In fact, at page 6 of 38 of exhibit G13, for instance, A3 was asking whether the trigger for detonating the bombs is like remote control, to which Dr. McPalm responded inter alia that we don't want to kill too much. If killing comes, it is just the way it should be, but we should be able to do this in a way that casualties will be on the minimum side. Then they talk about a few other things, including where there is a discussion about sort of abducting the president, vice president, and other people. Yeah. The person you were dealing with, the only woman,
yes, A6,
a soldier,
yes,
appears to have been playing, according to the judgment, yeah, the role of recruiting people that they wanted, because they wanted to recruit people. And they said that they were recruiting people, you get 50,000 cedis each, and they wanted about 20 people, and also testing of weapons and other things.
That allegation is completely untrue. A6 never played any role of recruiting persons or soldiers onto the group. A6 is a friend of A3. Mind you, A6 is a cook in the military. And cooks or caterers, people go to them because of food. They go there to eat or get food to eat and all that, or arrange for food and all that. So A3 and A6 have been friends, and they have Upper West connection already.
A3 is a fleet manager.
Yes.
Okay.
So he goes there to have a conversation. Say, "Oh, Charlie, I'm going to meet some friends at next door. Can you come along? And who can you call along to come along?" So Sule is my friend. Sule Awaf, who ended up to be PW3. So I can go with you. Then he joins them. Mind you, next door is a resort, a beach resort. People go there to hang out, to have beer and the rest. So
that's right.
They join each other. And under cross-examination, Sule Awaf was asked, "Did you know the purpose of the meeting before attending?" He says, "No, I wasn't informed." "Who did you go with?" I went with A6. We sat in the same vehicle.
So A6, A7, A8, A9, they are all soldiers.
Yes.
Right, for the benefit of our audience.
So A6 introduces Sule Awaf, PW3, to A3 and MacPam at the meeting. But she introduced as a friend without having knowledge of what was going to be discussed. And that was the only meeting she attended. Now, unfortunately, one meeting has been split into two videos where she's accused of attending two meetings, because obviously if you know the purpose of the meeting the first time and you go on to attend again, then in effect you are conspiring. You are agreeing to act together, or you are acting together.
Oh, so it's only one meeting. She's found it in a video and not two.
No two videos. Unfortunately, one meeting has been split into two videos and one other audio. So there are three exhibits against her.
Let's see what the appeal will say.
Absolutely. So we had, and during cross-examination, we put it out. Look at the video clearly. Look at the background of the video. Look at the dress, the outfit that people are wearing in the video. And tell me if this video is not the same as the video you had here.
But it is significant. What was she doing in that one video?
In that one video, it was a drinking conversation. They all met at the beer bar to have a conversation. And at the beer bar, any conversation can come up. In fact, at that meeting, the conversation was about the failure of the government. That the government has performed poorly. And there's a need for them to sit up and ensure that they will do the right thing, ensure that they will have the best government in the next elections. So they all had all manner of discussions, throwing words around. Unfortunately, the audio evidence that was brought, and the court rejected the audio evidence, that she had made allegation that we must eliminate the president. It was an audio evidence, and that audio cannot be attributed to her. We challenged it, and the court in its judgment, you would realize, the court said that they will place no weight on that exhibit, and rather place weight on a part of a video, which is the second video, where she's heard saying that she needs money for the boys. And also her saying that she cannot use her money to buy credit and call A3. And there was some exchanges between herself and A3 in respect of, "Oh, why can't you call? You are a member of the executive. Why can't you call?"
So,
and don't forget that at the background...
This is the law. Yeah. It's your legal right. It's your health law. And I admit that this discussion, the portion we have gotten to, is very technical and difficult. And you see, I try to jump in a way to help you join us. That's the best I can do. I'm not too sure they can get any...
No, maybe let me break it down.
So you
let me just finish up
this. Yeah.
So the mere fact that she says that she cannot buy her own credit and use it to call the gentleman now claiming that she is a member of the executive. Why can't she do that? Now, don't forget that at the background of this is that they are forming an NGO, TAG, which essentially is to educate the public, more or less a civil society group, to advance whatever agenda they have. And so if a member of the executive says that I cannot use my money to buy credit, you should buy me credit, what shows that that credit or that conversation is aimed at overthrowing the government?
But the TAG executive platform,
Yes.
which is the WhatsApp group,
Yes.
the judgment shows that this is the place where discussions about coup take place.
Thank you.
That's why ACP Abojo was saved, because he was not on that platform.
The good thing is that A6 was never on that platform. She was never on that platform. She was never on any WhatsApp
The soldiers
platform.
were not on that platform.
Not even not about the soldiers. I'm talking specifically about A6. A6 was never on any platform at all. She attended that meeting and said that she won't go for any other meeting again and never showed up in anything. So if you read the judgment will tell you that besides that, A6 was not found on any platform. Agojo's case, he was able to ask that, what is the purpose of this platform? And he was told the aim and objective of the group. It's an NGO, ABC, and said, okay, I'm ready to join. But he was never on the executive platform.
All right. So a while ago, you saw a portion of the judgment that was, yes, this is the portion that I read where the discussions were going on about bombs and casualties and how to deal with the president, the vice president, chief of defense staff, and so on and so forth. And they are speaking about the other side, which gives them reason to think that when they go on appeal, some of those who have also been convicted may get their freedom. Now, as we wrap up, the activities that are suggested in this judgment, the question I ask is, they give room for suspicion of the subject we are discussing, treason or high treason, don't they?
No. Yes, I would say no. I would say that yes, some maybe when you look at it, it is what happened.
That's somebody
not
gets
all of
together.
them. Not all of them.
Let's say Dr. Makpam.
Yes.
Gets together and say, I want to do ABC. He goes to look for somebody, a blacksmith, who is manufacturing guns. So they help him to buy material. Then he comes to the hospital, uses the X-ray laboratory, and turns it into a manufacturing hub to manufacture, guns. And there is an attempt to go and test them, and some soldiers that are being recruited into it.
Yes.
Some have actually infiltrated, and they are talking to the state that this is going on, and they have monitored over a period and gathered the evidence to use against them.
No. When it comes to what happened, may you so rest in peace, Dr. Makpam. Initially, when they started, it was the Sule who came in, who infiltrated, and now was bringing the idea of a coup d'etat, which Dr. Makpam, at a point, was buying into. Right. He brought the whole idea.
So it's like an agent provocateur.
Yes, agent provocateur.
That they planted the guy in, and then he led them on to do something.
There is
Evidence
evidence
to show that at some point they showed disinterest in whatever activity.
Whatever Sule was saying.
He kept pushing to the point where he told him that he's even going to Boko. He needs money to go to Boko. And this Sule,
Who showed disinterest at a certain point?
Makpam. And at a point, Sule was pushing him that he needs money to go to Boko to procure arms. And we have proven that Sule, who is PW3 in this case, actually got into the Ghana Armed Forces with fake certificates. We have been able to discredit this person so badly that I doubt how we could place any value on his testimony.
Samson, what I can only say is that, look, what actually happened was that when they were on the TAG platform, they registered TAG.
Yeah, TAG is a Take Action Ghana.
It's been registered.
Group.
Yes.
But when they started the platform, the kind of following they had on the platform and the kind of people who were on the platform, I'm sure that was when they realized that if we don't move in, and they intended to go on demonstration on the hills of the Ayawaso thing. That was when they barged in. So it was more of the platform thing that they started, and even Dr. Sam, he was always inciting the revolutionary things, and they always said, no, we want to go, because their aim was to become a political party. Their aim was to become a political party. And you see, there were eminent citizens who were on even that platform. So any donation they were making, it was publicly announced. But it was, I think that the fear that the kind of following was coming, that was when. So I'm sure that we are just saying.
When it is getting this
so
interesting about the other side that you may not be aware of, that the information that they are giving, then time just running out of us. I've got just about 30 seconds for you each about what you have to tell our audience about these offenses of high treason and treason, and what people should do not to ever get close to it.
I would say that when you are charged the treason and high treason, it's so broad. It's so broad that if you don't take time, you have to be careful on any platform you be, what you say, because the law is so broad. You could be brought in, inciting, attempt, or you agreed, or you just saw the person. You don't even have an idea. There's a conversation. You also poke your mouth into it. All this, if
get you into trouble.
The system can get you into trouble.
For me, my best advice is that now with technology, we all get on platforms sometimes without our knowledge.
Yes.
Always ask, what is the purpose of this platform? If you don't get the right answers, leave, exit the platform. If there's conversation in respect of anything that links to the element we have discussed earlier, report to the police.
Thank you. That's the best
and
advice.
Always keep your evidence.
Keep your evidence. My guests have been Victor Kojoga Adaudu, Managing Partner, Lord and Lords Practice Limited is a law firm, and Lamte Apanga, he is Managing Partner, Prestige Partners. I'm Samson Lardy Anyenini. This has been The Law. It's your legal light. It's your help law. We hope we have helped you.